Good evening to everyone, and welcome to our first interactive or live session of the preparation towards 2021 Ghana School of Law Entrance Examination. The all fathers, all males on this in this class, a very happy Father's Day, and we would like to first of all use this opportunity to remind ourselves about what is really important in preparing for the exams. And I always come to this first session in the sure knowledge that this is not the very first time you are learning the examinable, the selected modules. Ghana legal system and legal method, law, law of contract, criminal law, law of immovable property or land law, and what is the fifth one? Is the constitutional law, legal system, criminal law, law of torts, law of immovable property. Yes, just 6 models. And so I come here always very much aware that you have already learned this. That is why all of you can boast of having Bachelor of Laws degree or having your LLB. The fact that you have the LLB is evidence that you have already passed or you've already learned this particular these subjects. For that matter, there's nothing really in, for you. So we have come here just to assist you and guide you so that you know how to apply the things that you have learned or the things that you have learned and then you've revised, how to apply them to be able to scale this particular hurdle in front of you before you're able to continue with your legal education and hopefully become barristers and solicitors. So just so in case this is your first time of signing up to Ghana School of Law Entrance Examination Preparation with me, what I do is that I remind you that the entrance examination is a process. It's not an event. For that matter, there are various stakeholders as far as the examination is concerned. So we have a strict separation of roles. We have those who set the questions. We have those who set the question. Somebody is saying that he cannot hear me. Those who can hear me, can you indicate in the if you can hear me? Can you indicate in the chat if you can hear me? Oh, okay. All right. That is fine. And then, so those who cannot hear, I think you need to do something about your speaker. Yeah, so that you're also able to hear because there's so many of you are saying that they can hear me. Nevertheless, I will endeavor to record this and upload this on YouTube so that you can play it back in case you had a connectivity problem at your end. Yeah, so just let's manage. We'll finish soon, just about an hour and a half session. Thank you. Yeah, so I was just making the point that we have different people setting the questions. Different people, sometimes it even happens that those who set the questions may not even be those who prepare the marking scheme, and different people marking, and different people putting the mark scripts together. Of course, we also have chief examiner reviewers reviewing the mark scripts, and we also have those who will put everything together for us to have like the final results, which will be approved by the IEB, and then the Board of Education, General Legal Council, before it will come out for the public to know that whether you made it or don't make it. So that should tell you that the best thing you can do for yourself, just to learn well, revise well, and just know how to answer questions properly. I think that is the best bet. Nobody can give you any promise. Nobody can give you any assurance. At least I can best my last persuade on that, that the process is done with high integrity, and only those who apply themselves will make it. So that is it. Now, with respect to the questions too, nobody knows which questions are going to come. That's another thing that we should keep in mind. What IEC or the IEB do is that they have a pool of thousands and thousands and thousands of questions, and they use some sort of a lottery to pull out which questions they would like to give to students. And I'm told this happens either a day or just in less than 24 hours before the examination takes place, probably. So I'm just saying this thing to let you know that if anybody come to you to deceive you that these questions are going to come, just ignore the person. Any question you come across, you can look at them and work at them, but don't think that they are really going to come. But what is important is that you should understand basic principles, and then we should know how to properly answer questions. I mean, those are the very important general advice I would like to give to you. And again, for the MCQs or the multiple choice, so a machine mark them, as you know. So there's no human element. And that means you need to be careful, because just using the experience I have students from my university, Kwame Nkrumah University of Science and Technology, for example, you get students doing MCQ and they will not put their index number on the scannable sheet. I mean, that is a fatal mistake. You have to blame yourself and not anybody, because if your index number is not on the scannable sheet, we cannot actually attribute we can't attribute any marks, or we cannot attribute the script to you, obviously. That is one thing that I have to keep in mind.
Join the meeting.
Right, somebody can talk. And I've muted all of them. All right. Yeah, so those things are important, because if you've answered all the questions correctly and you don't have your index number on it, you get zero when it comes to the collation, because nobody has time to go and comb through over 1,000 scannable sheets to try and find out which candidate did not put his index number there. Don't forget that there are just too many students who are trying to pass admission. So if you make certain minor avoidable mistakes, nobody will have time to assist you. So that is what you should keep in mind. And that is what makes the exams appear to be a bit harsh or a bit rough. You just have to be disciplined and observe certain basic instructions. So please keep that in mind. For example, I know MCQ done somewhere about 9 students. They left their scannable sheet, the index number blank. So if you leave your index number blank, whose business is it to go and look for whose scannable sheet is there? Nobody will do that. So you have to take note of that. And then again, of course, you know the breakdown of the mass. The MCQ will attract 8 marks of, let's say, 40. And then we have 2 questions you have to write, maybe 2 essay or maybe 1 essay and 1 base question. So that is what you should get. And it will surprise you if I'm to tell you that some students talking to the examiners, like the examiners, when I'm coming to do this exercise, I go around to talk to some of them that I can get in touch with. Although I'm not supposed to disclose their identity, strict confidentiality. But talking to them, you get the sense that some students can get 0/30, 0/30 for the written component, one of the questions. So that is really bad, isn't it? And then you begin to wonder, how can that happen? It does happen. And talking to them, some of them, for example, some of them had their views redacted, and their views are their views basically that sorry, their views are basically that if you look at the scripts that students actually submit during the exams, you can put the students probably into categories. We can have what we call the strong candidates, and then we have what they call the weak candidates as well. And the examiners made their general observation relating to student use of poor and informal language. So that is very serious. You are writing a law at this level, and it is required that you use formal language. You have to avoid all forms of colloquialism or informality. That is very important. And especially those of you who have become so informal, so colloquial, of course, because of WhatsApp and other social media engagement, it makes you forget yourselves. And when you are writing a very serious task like entrance examination, you unconsciously bring in informal language, and that can cost you. So please, we'll be taking them point after the point. And then they also made observation with respect to deficit in substantive law. That is, some students, their knowledge in the law itself below standard. Somebody who have been through Bachelor of Laws education, and some also fail to adhere to structure for answering problem-based question. And then they also made observation with incoherent expression of thoughts and lack of preparation. So maybe let's take some of these points and reflect on them. For example, the strong candidates, they, the examiners applauded the strong candidates in the sense that the answer to, let's say, if you use like the last exams for the problem-based question was the law of contract. So let's use that for purposes of illustration. It can be anything. It can be tort, it can be land law, constitutional law, and so on. But let us use the contract as a point of illustration. And some of the examiners were highly impressed that some students demonstrated excellent understanding of the question, and they were able to note commonalities and differences between the common law principles and relevant status. In other words, there are some areas, typically if you are talking about contract, for example, there are some areas of the law in which the common law has also been reduced into a statutory provision. And some students to actually appreciate the coincidences where our statute law or statutory law has, for example, made modification or some departures from the common law. Strong candidates were able to also note that, and that is very impressive. And those who are considered strong candidates, obviously, are candidates who will score, if it's over 30, such candidates, the least among the strong candidates will probably be scoring, let's say, 20, you see. So those who score 22 and above, up to 30, they are the strong candidates. And the answers, according to that I talked to, are very thoughtful and well informed, in the sense that they're able to support it with the relevant legal principles and authorities. So it's my wish and prayer that all of you become strong candidates and be able to measure up to that standard. What about the weak candidates? Well, my friends from the examiners who shared the experience today also identify second category of candidates that we call the weak candidates. And the weak candidates, for them, their responses are characterized by failure to address or tackle all the relevant issues. And they also deploy inappropriate structure of answers. And I mean, typically, you see candidates when they are giving problem-based question, instead of following the basic structure of legal reasoning, that is your IRAC, identifying the area of law, or and also raising the issues, then taking the issues one after the other, and each of them, you state the relevant principles together with the authorities, which the principles emanate, and then you do the application analysis and draw conclusion to that issue, and you move on to another issue and repeat it the same before you come to draw the overall conclusion for that. Some students just ignore that and they use inappropriate structure. They use maybe some journalistic or just lay people's approach, and that is not how scenarios are tackled. Problem-based question answers. So the weak candidates, of course, they produce the weak answers. And their weak answers were primarily descriptive of different principles and elements without directly addressing the question. It's not the case that they didn't some of the principles. They stated principles, but they stated principles which were purely descriptive and did not actually respond to the heart of the question. So it's just one thing, just to babble or rattle some principles there, and another thing to be able to do what the question actually required. And some of the descriptions were not even supported by established legal principles. The person can use his own ideas to explain, but you cannot actually link them to any recognized legal principles. So that is problematic. The weak candidates also demonstrated incoherent analysis. Incoherent analysis in the sense that having even stated some relevant legal principles, how to be able to take the length and breadth of that principle and put it in the context of the facts of that problem and say that, okay, this principle is satisfied here or is not satisfied here. And for that matter, the issue, which is like the legal question raised, answered in the affirmative or not, they were not able to do that. So that is, and again, there was also paucity of use of case law. They were deficient in using case law and relevant statutory provisions to support the analysis of the issue. So that is another thing to observe from the weak candidates. And of course, there were poor grammar and spelling mistakes. Let me tell you something. With respect to the poor grammar and spelling mistakes, it can actually make examiners and markers angry. Let me tell you, some of them were quite emphatic in confiding in me that there are certain errors, certain mistakes grammatically and also just with respect to spelling. You make one slip one time, the examiner or the marker can ignore it, but they observe another occasion, making another grammatical slip or some other things like that. They get angry, and somebody can just stand on just one or two unacceptable grammatical error at this stage, or unacceptable spelling mistake at this stage. But don't forget that you are not first year law students. For example, constitutional law, contract and legal system, yeah, generally first year courses. If you go to most of the law faculties, at almost everywhere. Nevertheless, if a question is brought from any of these first year courses, for example, for you to answer in the of law entrance examination, we do not expect that the examiners are going to indulge you like how they indulge first year when they make some mistakes. So that is what you should keep in mind. So you make certain unpardonable errors. Some examiners or some markers can stand on that alone and fail you for that particular answer. And then they will, the person will fail you and then just write a comment at the bottom of the answer so that when the chief examiner goes over it and sees it, the chief examiner will just nod his head that yes, he or she agrees with what the person has done. And that will be the end of you. So I'm just giving you rare insight into how the examiners think, so that if you have done this a couple of times and you are not passing, you begin to understand why you are not passing. It's not really the case that anybody is deliberately failing anybody. No, that is never the case. So poor grammar and spelling mistake, that is a problem. Of course, that is the same as the poor use of language. And observation examiners have made is that a good number or significant number of students fail to communicate in formal written English language. Mind you, there's a difference between informal English and formal written English language. When it comes into the area of law, anytime we are writing about the law or we are writing in the area of the law, it is required of us that we will make use of highest level of formality. So that is one thing that we should keep in mind. And if you wanted to prove whether that is correct or not, now the judgments that you have been reading, do you see any informality in the decisions of the court? Certainly not. And the same thing applies to legal submissions filed by lawyers. They don't use informal language, so you have to pay attention to that. And many candidates are said to have actually employed poor grammar and incorrectly spelled many words. And there are certain legal expressions. I wish they had given me a list of some of the terrible things. There are certain words, if you cannot spell them properly at this stage, it can make your examiner really angry, please. It can make your examiner really, really angry. So make sure that you write using proper language. And also the handwriting. Handwriting is also important. You are not required to write like artists. But don't forget that there's something psychological about handwriting. If a person or examiner who has to read over 1,000 scripts, right, takes your and he or she, for example, look closely at your script and you've written in a very horrible, indecipherable way, cannot be deciphered, cannot be not highly legible. And it's going to go against you. Because if what you've written cannot be seen and he struggles to look at it, as he struggles to look at it too, he or she gets to know that You have also committed maybe some serious writing errors or some serious grammatical mistakes. And all those things psychologically could work against your paper. It can be against you. And that may result in you being awarded a low mark for that particular script. And of course, since you are the same person who are writing like the two answers are going to suffer the same fate. So you are gradually on the way to fail the written composition, and you are left with just the MCQ. So that is another thing that you have to pay attention to. Conversely, where you have written clearly and is neat, the person will take your script and the person automatically will get positive disposition towards your paper because he or she feels attracted to the clarity with which at least the paper appears before he or she will even look at the merits, like the content of what is there. So the person is going to read your answer with that kind of like that positive disposition that, oh, this must be like a good candidate, as it were. So that is how it works. So please, let's pay attention to our handwriting. That is very important. Well, they also commented on deficit substantive law that a significant number of candidates who started the last year showed a deficit in the application of substantive law. Of course, those who spoke to me, they spoke in reference to the problem question. I hope that in the course of our meetings, I'm able to talk to other examiners concerning the constitutional law question, which also came up, so that we can benefit from the observations that they have made. So as not to repeat some of those mistakes. Yes, so if you have gone through LLB successfully, and there's a question about capacity to contract, and you don't have mastery over that area of the law, then that is worrying. That is really worrying. And for example, examiners observed that some students had misconception of the effect of contract of what necessaries, and stated that once is determined that is the items are necessaries, then the minors are absolved from paying. I mean, that is clearly not what the law is. So what they are trying to say is that, you see, we are not saying all of you are first class students, or all of you should get A. I mean, that is the ideal. Nevertheless, basic knowledge of the law. And that is why I said at the very beginning that don't be deceived or don't let anybody fool you to tell you that these questions are going to come or those questions are going to come. No, I will be the last person to give you any such assurance. On the other hand, my interest lies in you being able to revise any area of the examinable modules in which you have forgotten or in which you do not have proper understanding. In addition to that, if you sharpen your skills in answering questions, you sharpen your question answering skills, then you are good to go. Because what it means is that you have reasonable understanding or insight into the substantive law under the six examinable models. And again, you also know how to properly answer questions, be it a problem-based question, be it an essay question, be it a multiple choice question. So once you have the skills and you have mastery over the substantive law, you are set. You can handle any question at all, and you don't need to actually, if you like, do some students with that. They've done punching, meaning that they have targeted a particular question, as it were, so that if it doesn't come, they are going to fail. No, you shouldn't be like that. So, for example, If you take like the last year problem-based question, yes, I think the age mentioned was 16 years. And talking to examiners, a lot of students were fumbling because they don't have a proper understanding of the issue of the age of majority in Ghana for contracts. Yes, we know that at common law, the age of majority is 21 years. And you could argue rightly that yes, that is true for making contracts in Ghana. So far as we've not had any specific legislation on contracts or contractual age, because we take like the Contract Act 25, for example, it's quite silent on the age of contracting. If you take the Sale of Act, it's quite silent. But if we take maybe legislation like Companies Act 2019, Act 992, is where it's explicit that the age of marriage is what is 18. And of course, the Children's Act and so on. Now, if you were able to acknowledge that yes, the common law is 21 years, and then the Constitution and various statutes also make allusion to 18 years, maybe with respect to some specific contracts or some transactions. Well, you get a good marks from the examiners. But the good thing is that if we look at the question which came, the age which was mentioned was 16. I think the age which was mentioned was 16 years. So since 16 years is certainly less than 18 and it's certainly less than 21, the age, whether the contractual age is 21 or 18, shouldn't have affected how students answer the question. That is another point to note. They also observe that students also fail to adhere to good structure of answer. As I have indicated, we have the standard method or the standard way of dealing.
Join the meeting.
Of dealing with questions that are of problem nature, and we what they call that the method basically require students to. It requires students to identify the area of law, set out the relevant issues, applicable principle for the various issues or resolution of the various issues, and application of the other relevant principles to the facts of the issues. I mean, these are the what they call like the hierarchy, and it is very common. It's very common, and every student who has been through the Bachelor of Laws in the common law world, not only in Ghana, you go to Britain, you go to Malaysia, go to Nigeria, and South Africa, all of them, the same method that they follow. Go to Harvard. You have to identify the area, or even the area for some people is not important, but at least if you have like the area, it helps, it directs your mind how to raise the issues. But the key thing is like the issues. What are the relevant issues? The legal questions would need to be answered before we can advise the parties involved. And then for each of the issues, you have to state the applicable principles. So you take in the introduction, you have formulated all the relevant issues. Okay, that is good. Of course, having stated the area of law and the relevant issue in the introduction, you come to take the issues that you've formulated one after the other. So you take the first issue, write it as a subheading, and you underline it as it were. And then under it, state all the principles. State all the principles together with the authorities. Authorities being the statutory provision or be the case law, as the case may be. Now, when you have done with statement of the principles and the relevant authorities that issue, then you go on to explain or analyze those principles and link them to the facts, the relevant aspect of the facts in the problem before you, and use that to answer the issue, because the issue is a question. The issue is a question that you have said. So use that to answer it. And as you do that, if there's a decided case in which the material facts are very similar to what you have, you will have cited that and then give us a quick insight into that and why you think that the conclusion that you are arriving at that issue is supported by, let's say, that particular decision, as it were. Or if there's a decision which appears to be very similar to the issue that you are discussing, nevertheless, there is an aspect of the facts in the problem before you which make you think that that particular decision will not be applicable and it should be distinguished. Despite the fact that on the face of it, there appears to be similar, it is not applicable. So you like to say that it's distinguishable or cannot support this particular, then you could also do that as well, so that we know that you understand the various principles. Now, when you are done with that particular issue, you move on to another issue and you repeat the same, that issue to underline it as a topic, you state the relevant principles under it, and then you do as I've just explained. And you repeat this for all the issues. When you are done, you move on to your big conclusion. And it's in a big conclusion that you are going to do the advice, where you are asked to advise the particular party. Now, what was observed and what is usually observed, even from my point of view as an examiner in my own university, is that some students fail to follow this simple, basic, standard approach. And they will just start by advising the subject, advising the particular party. And once you start doing that, you are going to suffer from incoherence in your thinking, because you'll be saying certain things which ought not to have been said at the time that you said it, and ought to have waited for some other statement to be made and all that. All those things affect coherence of thought and the quality of response or the quality of the answers that you're able to give. So that is another thing that was observed. Of course, as we say in our local parlance, that if you see that one parent is advising another child, then you draw lessons from that, and you draw from that advice as well, so that you don't fall into such pitfalls. So these observations are also meant for our own learning, so that we avoid falling into them. They also observe that there's a lack of preparation, right? Lack of preparation by students, and some students reading their scripts were ill prepared, not very prepared for the examination, and it was obvious. So this brings up the question: how are we preparing for the examination? For example, some examiners say that some students fail to set out applicable legal principles and provided no legal authority. And some wrote only a page or half of a page. So if you are going to write an important examination in the sense that it's going to determine whether you get admission to the law school or not. Of course, it's not more important than your LLB examination, because LLB examinations is what will let you get a degree as an LLB holder. Nevertheless, if you get the LLB degree, you still need to battle for space in the law school. And you get that through the entrance examination. And that is why you are going to write an examination which is important as that. You go and write just a half page. or just one page. And even that half page or that one page is not quality, in the sense that no legal authorities are cited and so on. So clearly, you are not going to get anything more than 3 over 30. You're not going to get anything more than 3 over 30. So that is one thing that you should note. And if you are getting 3 over 30, then you have to know that you are already on the path towards failure, and you're not going to make it in that year. Because if you go 3 over 30, you are left with the other 30. The other 30, somebody who has started behaving, having half page or one page, getting only 3 over 30. Only God knows if you can make it more than 10 over 30 in the other people in the other question. And the MCQ too, you don't know. And you are supposed to get the 50 marks, isn't it? So all those things can work against us. You have to be very careful. So there may be the preparation. Let me say before I move on to the incoherence that they observe. The preparation, I must say that say subjects are not many. So it's not a question that you are going to be overwhelmed. So I'll be surprised if any students say that I'm overwhelmed by the enormity of things that need to be learned before I go and sit for the exams. No, because mind you, you have learned it already. It may well be that, well, some of you finish school maybe 2 years, 3 years, 4 years, 5 years. Some are even 6 years or 7 years still waiting to go to the law school. I can perfectly understand that. Nevertheless, you must have a structured approach towards your revision. You have to get a timetable for yourself. And as I said, retune your mind or reconscientize yourself that you are going to make sure that if you take any of the same subjects, all the topics, you understand them. If there is any topic that you don't understand, you have to seek assistance, either from your friend or from any of your teachers, as it were. So that way, you are assisted to get understanding of the relevant substantive matter. As I told you, that is very important. And again, for each subject and for each topic, there are key authorities, or there are common authorities which are very standard, that everyone who has studied that area of the law will be familiar with that. So for those common authorities, you too should be very familiar with them. Because if you should write an answer and the usual authorities which are known in that area cannot be seen, that will be very disappointing, and that can go against you. So please, you have to pay attention to that. Then they also touch on incoherence. They touch on incoherence, the fact that some students were very incoherent in their thought processes and the expression of their thoughts and ideas. So it was observed that some candidates rightly stated and discussed the applicable legal principles, but failed to logically apply it to the facts in question. Meaning that some students could state the law, but they were not able to do the application. But we also got situation where students will state the law, apply the principles to the facts, and yet will give advice which is not in agreement or which is inconsistent with the principles that they have discussed. So that is incoherence. So these are some of the thoughts which I gathered from some of the people who were the examiners in the last year examination. And of course, my own addition in terms of what needs to be paid attention to by students. Certain unpardonable errors which students make. Failure to understand the question. And if you take the last year's question, especially the question on the crisis election, possible election crisis created by the COVID-19 and the succession, power succession in the country and all that. Some students, I'm told, were quite horrible, and they failed to understand what the question was about, and rather started talking like journalists, talking about the effects of COVID-19 without going to the Constitution and letting them know that, yes, the Constitution has provided its own mechanism in terms of succession of what? Of authority, of power. If the president is not there, who is next? The vice president. Who is next? Speaker of Parliament, Chief Justice, and so on and so forth. And then situations in the Constitution in which you can prolong the life of Parliament, for example, in which the lifespan of Parliament can be prolonged, or the Constitution has got what we call the residual power. Has Parliament got residual legislative power in respect of matters in which the Constitution is, if you like, silent, or some suppose, if you like, a lacuna in the Constitution, as it were. These were some of the critical matters which needed to have engaged attention of candidates, but students were just dancing to the gallery, doing their own thing. So please, you need to understand when you see the question, don't think that you've just seen a word in it, which is very similar to what you have been actually be tipping or hoping to come. So you are just going to start writing. No. Regardless of how similar the question you have seen on the paper, what you have been anticipating, what you have been learning, prudence or wisdom requires that you must still take your time, read the question closely 2 or 3 times, understand what the question is asking you to do. If you understand what the question is asking you to do, and if you're able to put your thoughts together in the form of answer planning, even if the time is just coming to an end, because you understand the question and you have the point, you have a way to be able to get your thoughts reduced into writing. If you are going to be, if you are not going to be quite nuanced, quite detailed with respect to all the points, you'll still be able to cover the grounds and be able to make a positive impression on the examiner, rather than just not trying to understand the question and put your thoughts together well, and I will just start doing anything, and that could go against you. Again, when it comes to problem-based question, as you've said, you have to follow the hierarchy, and you need to identify the area of law. And the area of law, I would say, for purposes of Ghana School of Law entrance examination, stating the area of law would also be done with an expanded approach. And what do I mean by that? That instead of, for example, simply writing capacity to contract, it will be helpful to say that the relevant area of law is law of contract, particularly or especially capacity to contract, and maybe frustration or intention to create legal violation, as it were. The reason why I prefer to add the big subject area is that the law school entrance examination is just one composite paper. It's just one paper. And they don't divide it into maybe this area, section A, maybe contract, section B, constitutional law, section C, tort, and so on and so forth. And because of that, it will be useful if you can say that maybe the area of law is the area of law is tort, particularly trespass to person or defamation. or something like that. So that way, it will help you to also direct your focus, because since we have six subject area which are being tested, and they don't tell you whether this year the written component is going to come from subject A or subject B, and so on. That will make it a challenge. And for that matter, it will be useful if you use that strategy. And again, inability to take advantage of clues to determine the area of law. Sometimes if you read the story very well, right? If you read the story very well, the story should be able to help to zero in the area of law which is being tested, as it were. For example, Kwame, yes, one. Yeah, sorry, I got a call. Yeah, so if you pay attention to the story, you will be able to get the useful clues. For example, Kwame slapped Kofi, leading to Kofi's glasses being advised Kofi regarding Kwame's liability. Now, if the question said advise Kofi regarding Kwame's liability, of course, we can talk of liability in criminal law, but liability is a more common language which is used in the civil law rather than criminal law, like especially in our part of the jurisdiction. So, since the question said advise Kofi regarding Kwame's liability, we would not expect that you will be discussing more of, like, if you like, the criminal law. That is well, but your mind will gravitate more towards civil law, particularly the law of, as it were. So that is what I mean. Of course, we appreciate the fact that sometimes all the examiners also frame their questions. It's give rise to some ambiguities, and we appreciate the confusion that students will have to go. But since we have a very little control over that, and we are students, and whatever question that is provided, we need it. We just have to make best of the situation. Yeah, I think I've talked already about poor handwriting and lack of clarity. I want to talk about the poor grammar. And of course, the final thing in terms of the general things that we are trying to remind ourselves, which I will touch on, is the fact that if you are a person of faith like me, to learning, you also have to pray, because when your papers are being worked on, there's a human element. And all the time, I tell students that there can be a genuine error which can affect you, not because someone has intended to actually harm you, but maybe a genuine error in terms of the collation. You can have interpositional error or wrong attribution. Maybe your marks may accidentally be given to another person. All that. And for that matter, it is useful to always pray when you've done exams, so that everything will go on well. So these are the general things I would like to draw your attention to. And my first live interactive session, I try to take some of your interests and your concerns so to guide how we do the specific practice. But in tandem with recommendation of the examiners, I will prefer that we sharpen our question answering skills. I think it's very important. Okay, so I'm going to allow you to also raise issues in terms of some of your expectations so that it will help us in planning to help you. Yeah, so I've seen, let me look at the hands. Oh, it's up. Okay, let me see. Participants. Okay, Jesse. Jesse, you can talk.
Good evening, sir. Thank you very much for the briefing. I want to know if you are advising someone in a problem question, what does it really constitute? Like I want to know what should come into it.
Like when you're advising someone a problem-based question,
Yes, please.
what does advice constitute? Is that it?
Yes, what should you say?
Okay.
Because I think I heard somewhere that you can simply give like an everyday advice, like maybe go and make up with a person or something like that. I
Okay.
want to know if it's correct or there's something more that goes into advising.
All right, Jesse. Okay. So Jesse's question, if you are asked to advise someone in a problem-based type question, what does it really entail? I mean, that is very good question. And of course, it is tempting to always rush to go and tell the person what he or she to do. But for us as students of the law, as future lawyers, we are supposed to think and talk like lawyers. So for the common law reasoning approach is that if anybody present any story to you, you have to do a classification of the problem in your mind in terms of which area of the law that particular problem or story fall under. Where will you place that story or that problem? So you need to do that classification in your head. And having done that, you ask yourself, if this is the area or these are the areas of the law relevant to the story, what questions arise from this story in the light of what I know under this area of the law? So you raise questions, what we call the issues. Now, having done that, you have to take each of the questions and then tell yourself what principles are relevant in trying to answer this question. So you tell us the principles, and of course the principles are always emanate from provisions of Act of Parliament or from a judicial decision, that is the case law, as it were. So having stated all that, then you go back, apply the principle to the relevant aspect of the facts of the problem, and then use that to answer the question or the issue that you have formulated. Now, when you have done this for all the issues that you were able to raise from that scenario or that story, the way will have been cleared for you to be able to advise the particular person that you ask to advise in terms of what he or she should do. And that way, your advice is going to be well-informed advice because it will be like a reasoned advice. Reasoned advice in the sense that you have considered all that needs to be considered. But if you just started by advising the party, oh, do this, do that, what is the basis of that advice? And that is what makes us law students. Yes. So Jesse, does that assist you? Jesse. Jesse is gone. Okay. All right. Any other? Okay. Who? Okay. Yahaya. Yeah. Yahaya Amantana.
All right. Yes, thank you. Thank you, Mr. for this gratuitous briefing. I want to find out, sometimes you have them asking you a general question, for instance, a question bordering on the economy. which one can say that it's not a law question. I want to find out how you would handle such a question from the law perspective.
Okay. All right. Thank you, Yahaya. Good. You can have like a question. As Yahaya said, bordering on the economy. And if you read the question, it does not appear to be illegal, or like you will not ordinarily consider it as a law question. I mean, that is Yahaya's issue. Good. Now, what I will say is that we have to remember that the paper we are writing is a paper for law students and not ordinary law students. Law students who have completed Bachelor of Laws degree. Law students who are about to start the professional law school. So that is the environment, that is the context. Even if you are asked a question about religion and there is nothing on the face of it which suggests that it's a law question, it is expected that you bring your knowledge and thinking as a law student to bear on it. So any question which is asked, regardless of how it appears, you have to bring your thinking as a law student on it. Even if it's on the economy, if it's on the economy, it depends upon the type of the question. There may be something relevant based upon your understanding of the Constitution, the directive principles of state policy, or the role of the Bank of Ghana to regulate the monetary policy and so on of the economy, as it were, depending upon the particular specifics of the question. You will still, so all that you have to remember is that this is a law exams. And when the question is asked, we don't need, unless the question is directed due to a particular area or particular perspective, you always have to, even if you have to do what we call the creative thinking, your creative thinking should be creative thinking from the point of view of the law. Yeah, so yeah, I think that is what I can say. Mike L. Mike L. Mike L. Mike L. Yes, you can go ahead.
Thank you very much, sir. Sir, I would like to find out. Sometimes the section B, they would ask a question of discussion. So in such questions, it will cover, for example, talking about the issue of LGBTQ plus, you know, and the discussion covers areas of constitutional law and criminal law. All right. Another issue is the galamsey, whereby there was public reaction concerning the burning of the excavators. People are saying that it's against an act, and others are saying that the president acted based on public interest, which is in line with the Constitution. So in such discussion, are you going to look at, first of all, how would you go along with it? Because it may seem like we are going to discuss both constitutional and criminal law. At the same time, it may even go to the extent of tort.
Okay, so because you have raised,
how?
Yeah, so Mike, because you've raised an interest on that, I will try and formulate one or two questions around so that in the course of our lessons, we will discuss them, okay?
All right, sir. Okay, thank you.
Jamfi.
Yes, sir. Thank you very much for this session. My issue has to do with the IRAC.
Okay.
Now, I did the LLB with London, University of London, and what they actually taught us appears to be quite different from what I am hearing from you today. Okay. Now, from their point of view, the IRAC is supposed to be applied even as and when you do your analysis. For instance, you stated your area of law. You've come to your issues. Now you are analyzing the problem question that you have been given. So as you analyze, we are expected to do state the rule and then apply the rule to the fact given and then conclude as we move along and then give a general conclusion.
Yes.
As your advice.
Yes.
I don't know whether that is the same.
I've taught in UK. I used to teach in Lancaster University. I did that for 3 years, and we use like the same. I think the Iraq over there is not different. Like maybe speaking with reference to my colleague who was like the convener of the contract law, his preference was that. Of course, I can also understand him. He was not interested in the A. You know, Iraq, A, I.
Yeah.
So he was not interested in the A. That is the area of law. You was just interested in the I. That is application of the issues, and then the principles or the rules and the application. But because he was speaking, let's say, in the one particular subject area, if we are teaching, let's say, a particular area, that is fine. But if you added area of law, you've not done anything wrong. It's all right. And I would say that in Ghana, if you look at the majority of the lawyers or those who have studied law in Ghana, I think the predominant practice is the IRAC beginning with A. So that the A is area of law. And then the I, the R, the relevant rules or principles. And then the what do you call the application on the analysis and conclusion. Yeah, so you do that for each issue as I indicated. And then when you have finished addressing all the issues, you have one big conclusion. So what is going to happen is that the typical structure of the lesson should be you have an introduction. An introduction, what are you going to do? The introduction, you're going to do just one simple thing, or if you like two simple things. You say like the area of law. From the story given or the area of law relevant to the problem stated is the law of contracts, particularly consideration and remedies for breach of contract. Let's say you are or the areas of laws relevant are law of contract, remedies for breach of contract, and maybe tort of negligence in law of tort. Because it is a composite paper, so I'm just imagining that it is possible to have more than one area of law being examined the problem-based question. It is possible. I'm not saying that it's always going to be that, but I just want us to also keep our mind open so that if in a particular year, maybe like your time, you happen to have, let's say, more than one subject area being tested in the problem-based question, it will not become something strange to you. So that is it. Okay, so
no, I don't think my issue was addressed. You know, you were saying that when we say the issue, and then maybe we underline the issue, and then we state the principles, and then probably the case law applicable and all of that.
All right.
And then probably we go to the analysis.
Right.
But I am trying to, and then you conclude
on that, and then you move on to another issue. You repeat
okay.
This. And depending upon number of issues that you have, if you have, let's say, 3 issues or 4 issues, you're going to take each of the issues. You know, like of course in the introduction you outline the issues, and then you come and take the issue one after the other. So each issue, as I say, you make like a subhead, like your heading, you underline it, and then underneath it you state the law, and the law always goes to the authorities. And then when you are done with that, we leave a paragraph and then you start the analysis and the application, and you conclude on that issue, and then you leave it. You go to another issue and repeat the same approach.
Yeah.
When you are done with all the issue, when you are done with all the issue, you come and draw your what they call your big conclusion.
Yeah.
You can have like maybe like a one big conclusion in which you are going to do like the advice if you ask to advise, and that is going to be a synthesis of the smaller conclusion that you had.
Yeah. Thank you very much. I understand now. Thank you.
So, Mark, you are Zori. Mark, you are Zori. Mark, you are Zori.
Please.
Yes.
Thank you very much. There are times a question will require you to answer the question or a memo or something. How fatal is it if you answer without resorting to the technical requirements of, say, the brief or the memo? If you answer the question without having due regard to, say, the requirements of a memo or a brief, as the question may require, is it fatal?
Right. If you did not write memo at the heading of your answer, it's not fatal, except that if you did that, probably it will give you just 1 or 2 marks extra. But if you don't do that and you have addressed the substance of what the memo was supposed to address, you get your points. In any case, you haven't done legal drafting. That is not the focus. But if you get like the memo type all the time, it's taking your mind to an essay type question, in which case maybe you are being asked to send a memo to Law Reform Commission regarding maybe legislating unfair contract terms or making unfair contract terms legislation for Ghana. Maybe you have to submit a memo to Law Reform Commission in terms of what should go into that law or what should not go into that law. So that way is like you're doing essay. You're supposed to give us an account, the development of the relevant area, the problem areas as far as that law is concerned, and the recommended solutions or reform, as it were. So those are the things that is expected of us in such an exercise.
Okay, thank you, sir.
Okay, so Joshua, Abba, and then we take Cecilia. Joshua. Joshua. Yeah, Joshua, go ahead. Joshua, go ahead. Okay, Joshua is not talking. Okay, then let's say Cecilia. Cecilia Ayilo. Cecilia, is it mistake? Yeah, okay, all right. Cecilia, let's hear you.
Okay, thank you very much for this insightful information. We are very grateful. I just wanted to find out, is there any specific techniques that we can use to tease out what's called issues in related problem questions? If there are any techniques or anything like that that you can give out, so we'll be grateful.
All right, so how to raise issues. Okay. Now, in terms of how to raise issues, I would say that the only technique out there is, first of all, to read the problem. You can read it if you like quickly times. And as you read, pay attention to each sentence. because you know the law, as you read the problem, tends to ring bell in your ear, and you quickly underline and dot them around the story. Just be writing them around the story. Then when you finish reading it 2 times quickly, then you come back and do the slow reading. So you start from the very first sentence, you read it, and then you ask yourself, does this raise anything? If it does, you quickly write it. If it does not, you move on like that. So when you have engaged each sentence, you notice that you have probably raised so many issues. And some of the issues, when you look at them, can be merged with others. Or some can be made, if you like, a sub-issue of a main issue. And some may also have to be crossed out because they appear to be a repetition of some other issues. That way, you have done the pruning and you get the reasonable number of issues which can be discussed. So if you follow that approach, you notice that no important issue will escape you. You'll be able to really identify or spot the salient critical issues that need to be raised for discussion. Yeah, so that is it. The lady who has a question. Joshua, you can unmute yourself now.
Thank you for that. I've done that. Can you hear me, Doc?
Yes. Yes, Joshua, go ahead. Oh, Joshua, you keep muting yourself. You're muted. No, Joshua, I think there's a problem from your end. So write your question in the chat. Okay. It appears your mic keeps going off. So let's say, Joshua, write your question in the chat. Janet.
Yeah, hello, sir.
Yes. Yeah, Janet, go ahead.
Yes, good evening.
Good evening.
Yeah. Can you hear me?
Yeah, Janet, I can hear you.
Thank you for the insight. Yeah, thank you for the insights that you've given us.
Very well.
I just wanted to plead that as we move along, is it possible that you would walk us through how to answer maybe a scenario question to the specification of Ghana law?
I think what I would say is that problem-based question, we don't have Ghana Law School specification, but we have specification of standard LLB. Because what they are using for you is what is expected of LLB students. So the Ghana School of Law does not have a different standard when it comes to your entrance examination from what is expected of you in the LLB program. So we try that as well, Janet. So let's take Philip Zanlerigo. Joshua, write your question. I will mute you, but I think you have a problem with your mic.
Hello, Doc.
Yes.
Doc, can I talk? This is Joshua.
Yeah. Oh,
hello?
Joshua. All right.
Okay.
Yeah, Doc. Doc, can I talk, please?
Yes.
Thank you. I'm grateful for the opportunity. Doc, I read my LLB at Central, and in Central we have been taught 2 ways of approaching questions. For instance, Judu Tufo is interested in the Iraq some of the lawyers are not interested in the IRAC. Okay.
Really? What are they interested in?
Yes.
What are they interested
Come
in?
again?
Like the other people
Yes.
are interested in?
They want you to approach the questions direct. They don't want you to raise issues.
Oh.
And then
please.
Yes.
Problem-based question.
Problem-based questions.
Oh, that is wrong.
They want.
Oh, that is wrong.
That is wrong.
Because even you see what is happening is that the IRAC is not somebody. IRAC is consistent with the common law method. And what do you mean by the common law method? If you take a report, take the Ghana law report, take the Supreme Court of Ghana report, or take any of the English reports, All England report, or take any report. You read the case, notice that the case has a certain structure. If you read three judgments, you see that there's a certain structure. At least the issues will be identified, and then the law is discussed, application is made, and then conclusions arrive at. So that is how the common law reasoning is, and that is the same as based question in the law school. Okay, so we take our last 5 minutes and then we end the session. Somebody is saying that he does not agree.
No, Doc, what he didn't hear me. I am saying that Jude wants area of law. Please don't misquote me. I said Jude 24 wants area of law, but some of the lawyers don't want area of law. So I am not saying Jude did not want it. He wants area of law. When you raise the issue, they want you to raise the issue. Then you bring the statute or case law under the issue, then you bring the area of law, then you draw the conclusion on one of the issues raised. Then you move to the second issue, you pick the statute if there is, you pick the case law if there is, then you come to the analysis, then you draw conclusion. This is what you should train us to be doing. But in some of the laws, for example, company law lecture, if you do area of law IRAC, you get offense. You understand? So we get confused along the way. But you kept on saying that we should be consistent. The area of law, the IRAC, he takes it very serious. So please, the one saying or typing something there as if I'm not I'm in a way painting you black. Please, I'm very sorry. Right. Listen to me carefully.
All right, no
I'm very grateful.
Right. Okay, so let's some.
Hello, Doc.
Yes, Sam.
Doc, good evening, sir, and thanks for this session. I had wanted to find out when you were talking about some of the areas that were lacking for students. You discussed the issue of handwriting legibility. Okay. Hello, Doc.
Yes, please.
Hello, Doc.
Yes, I can hear you.
Yes. This is an issue. Yeah, this is an issue that has followed some of us for a while now, because in the exam setting, you
Yes.
You are pressed for time, and so you are unable to write as if you had the time. So are there any pointers you could give us on how to
be
able to do better with the time allotted?
So for the handwriting, my advice, when we are learning to, maybe like you do yourself a lot of good if you can say that for every learn, at least every day, if for nothing at all, I'll try and solve one question, one law question a day. And then when we are solving it, sit down and write like you are writing examination. You time yourself. When you finish, you have your books. You can take your answer and use your books to go through your books and to mark yourself. And the more you do that practice, you notice that you become conscious of how you write under pressure, and then you become conscious of how you're able to work gradually to improve the quality of the writing, especially its eligibility. I think that is very important. And then let's be clear, because the examiners, let's say somebody is marking 500 script, 1,000 script, 1,500 script, and so on. There's no pressure, and the person has to finish within few days. So there's no luxury for tolerance of poor handwriting. We cannot. So we need to polish it, as I've said, and you can polish it by practicing on your own. And not for you to write like an artist, that is not important. But just be clear, write with clarity in the sense that like somebody can see it and read it. That is the point. So when you are writing, remember that you're not writing for yourself, you're writing for somebody to read. You're writing for somebody to read, then it should be written in such a way that the person can read it. I think that is all. Okay, so I think we are done. Okay, so I don't seem to have anybody's hand up. And this provides a very convenient juncture for us to end the class. So we will send you notice about our next class. And I will endeavor to upload recording of this on the YouTube. So have a very good night and thank you.
Thank you, Prof.
Thank you, sir.